world of intellectual property will never be the same again. OpenAI has defeated the publishers, and it has been resolved that AI does not violate copyright. Mark this date, November 7, 2024, will mark a milestone in the battle between artificial intelligence and copyright. A strong judicial ruling exonerated OpenAI from accusations of plagiarism and intellectual property violations, dismissing a lawsuit filed by the publishers Alternet and Raw Story. The decision reinforces the legitimacy of using open data in training AI models and questions the validity of many ongoing legal claims against these technologies. Reasoning behind the ruling. Key arguments in favor of OpenAI. AI training does not infringe copyright. According to the arguments accepted by the court, the process of training models with publicly accessible data is protected by the principle of fair use. This practice does not constitute any infringement. The legal principle of fair use extends to music, images, videos, and all information that could be subject to intellectual property. AI synthesizes, it does not copy. The court emphasized that OpenAI's models do not reproduce literal texts, images, or videos but generate responses based on synthesized information, eliminating the possibility of exact reproduction. The dataset is immense, making exact copying impossible. The vast volume of data used by the models makes it practically impossible to produce a literal reproduction of any specific work. That is, copyright infringement can only be discussed if a specific topic by a specific author, subject to copyright, is reproduced. A topic like those created by the Beatles. No, regurgitation is not demonstrable. The plaintiffs failed to provide concrete evidence that ChatGPT directly replicated their articles, a burden of proof indispensable for any legal claim, even if this could have been true in earlier models that are no longer in use. The judicial decision is a blow to copyright lawsuits. Judge Colin McMahon dismissed the lawsuit by Alternet and Raw Story, emphasizing that their main argument was not the removal of copyright management information, CMI, but the use of their articles to train models without compensation. However, the judge stated that this complaint, while understandable, did not fit within the framework of the DMCA, meaning there was no piracy of content. In her ruling, Judge McMahon described the evidence presented as insufficient and emphasized that the alleged damage lacked legal grounds. This ruling sets a precedent that could limit future attempts to litigate against AI companies for using open data. The unmitigated defeat of Alternet and Raw Story represents a serious blow to publishers worldwide who sought to curb AI's expansion or, at the very least, extort multi-million-dollar artificial intelligence companies through lawsuits. Although the plaintiffs planned to appeal, the judge expressed skepticism that they could prove recognizable direct harm. Experts like James Grimmelman, a law professor at Cornell University, consider that this ruling has the potential to drastically restrict claims related to AI model training. This decision could eliminate the legitimacy of future copyright infringement cases against artificial intelligence companies. Moreover, the view of the American magistrate has been embraced by the circle of power that, along with Trump, has won the U.S. elections. The idea that AI companies are a national priority means there is no reason for them to respect the intellectual property of the rest of the world. And the proof that this is serious is that Donald Trump has publicly threatened that the United States would leave NATO if the European Union dares to sanction X, Apple, or any other American tech companies. OpenAI's victory not only strengthens its legal position, but also reinforces the legitimacy of the artificial intelligence sector. Jason Dutram, a company spokesperson, stated, "We build our models using public data, protected by fair use and established legal precedents. Those academics, commentators, and entities who claimed that AI outputs were illegal will once again have to be silent, because this significantly affects concepts like private copying, public reproduction, and the royalties associated with them. Practical example: in a few months, we'll ask our AI to create a movie with a plot similar to Casablanca, starring someone resembling Humphrey Bogart and someone resembling Elle Macpherson, set in Hawaii, and with 3 risque scenes. The result, a 120-minute film, will be stored on our hard drive or phone. None of this will generate reproduction, private copying, or intellectual property rights. This is no joke. We are just months away from Netflix offering this option. The judicial ruling reflects a paradigm shift. AI is not illegal, nor does it infringe copyright, as long as it operates under the principles of fair use and is American. In other words, more than a century of peaceful jurisprudence from our Supreme Court and hundreds of Supreme Courts across all states that are or have been has just become history because of a decision by a Manhattan judge. After all, the empire is the empire.